Welcome to the iHowz briefing in the House of Commons on November the 22nd. I think you might find this debate very interesting. My name's Peter Littlewood. I'm with iHowz, the Landlord Association. I'm delighted that we've got a couple of people with me. So in a moment we're going to have Andrew Butler KC who's going to present the case. But prior to that, I just want to mention, some of you may be aware that our original sponsor was Craig McKinley down south. Unfortunately, Craig became quite ill. He's on life support for a while, 4 weeks or so ago, quite some time ago. And he's still in hospital, I understand, is that right? So yeah, he's still in hospital. So I think, I won't speak out of turn if I say I think the collective room will wish him well, quite frankly. So, you know, well, and thanks to Craig for what he did. I'm delighted that Sir Christopher Chuck was able to step in at the last minute to be our sponsor. He got rather numbered for it, so. So what I'd like to do, with no further ado, is hand over to Sir Christopher to do a few introductory words, if you're all right with that.
Okay, thank you very much indeed. And can I indulge everything you've said about Andrew? I mean, he's one of the hardest working members of Parliament, and for him to be hospitalised in the circumstances was a disaster. But he's, by all accounts, making a good recovery, and we wish him well. I come to this subject as somebody who was a minister in Margaret Thatcher's government when we were introducing the housing, what became the Housing Act 1988. A supply-side reform, in my view, like no other. One which overnight expanded the private rented sector by freeing it up and encouraging people to come into the marketplace. And the rest is history. So it was with a very heavy heart that I found that my own party was now proposing to undermine what was one of the key parts of that legislation, which was the ability to be able to set up a short hold tenancy agreement whereby the person who was the landlord would be absolutely certain that at the end of a specified period they would be able to recover possession, and the person who was the tenant would know that they had security of tenure for the specified period of that short hold. And we've now got a situation where, as you will know, the government has brought forward legislation to abolish Section 21, and iHowz is very keen to move some amendments to mitigate, ameliorate the worst impacts of that. And to that end, they have asked Andrew Butler to come out and support and articulate the reasons why this bill needs to be amended. And so I very much support amending the bill. I would prefer it if the bill had never had a second reading, and I'd hoped actually that we would have a change of Secretary of State in the reshuffle and that the bill would then have been dropped, but that hasn't happened. So we are where we are, as they say, and so over to you, Andrew.
Andrew, the floor is yours. Thank you very much.
If you've got a hearing aid in, take it out, please. That noise.
No.
Sorry.
Well, thank you, Peter and Sir Christopher, for those introductory words. My name is Andrew Butler. I'm a barrister and KC at Tanfield Chambers in London, and I'm here to present this proposal for iHowz, particularly concerned with the idea of abolishing no-fault eviction. Now, from what I've followed of the debate so far, it's taken on a somewhat binary nature, with many speaking in favour of the abolition of such evictions and many speaking against. It's been a somewhat binary debate with no truly imaginative compromise proposals put forward. And it's interesting that Sir Christopher alluded to the history. When I came into practice, it was shortly after the enactment of the Housing Act 1988, before which the legislation had been the Rent Act 1977, with no scope for no-fault eviction. As Sir Christopher says, the 1988 Housing Act introduced assured short-hold tenancies, but only if there was a convoluted system of the giving of notices followed before a tenancy was entered into. Just to take the history forward from there, in 1996, the Housing Act of that year was passed, and assured short-hold tenancies became the default option, so you actually had to actively contract out. And now it's proposed that the pendulum should swing back the other way to where we were at the time of the Rent Acts. And that seems to me to be a retrograde step. So the iHowz proposal, it's set out in papers that some of you may have had the opportunity to read. It's very simple. It leaves intact the current system of assured short-hold tenancies, but it contemplates that if notice is given, the last 2 months of the tenant's occupation will be rent-free. Now this serves two purposes. The first purpose of the rent-free period is to deter the landlord from relying on no-fault eviction unless it's truly necessary. And the second and more important purpose is to give the tenant the financial wherewithal to find new accommodation, because that, on my understanding, is one of the strongest arguments in favour of abolishing no-fault eviction, that it is a common cause of homelessness. People are removed from their accommodation without fault, and they simply don't have the means to put down a deposit and take the other steps they need to find a new place to live. Now, how would this work in practice? Well, the obligation to pay rent would still exist, but it would be suspended. And if the tenant were to give vacant possession by the time specified in the notice, it will not thereafter be enforced. If the tenant does not give vacant possession by the time specified in the notice, the obligation to pay rent for that 2-month period is resurrected. And if everything else is in order, the landlord can take proceedings in the county court and get an order for possession. The tenant therefore has a strong incentive to comply with the notice and to vacate in good time. Now, unconnected with this, there are two other aspects of the iHowz proposal. First, there's one that's covered in my paper, which is the proposed extension to notice periods. It's recognised that particularly for tenants who have been in occupation for a long period of time and are blameless, simply being ejected at 2 months' notice is a bitter pill to swallow. And it's proposed that the notice periods can be lengthened commensurately with the duration of their occupation. And secondly, an aspect not covered in my paper, but which I'm asked to mention, which is that iHowz oppose the abolition of fixed-term tenancies, which is another part of the Renters Reform Bill, and they do this in the interest both of landlords and of tenants. It simply isn't in anybody's interests if somebody can enter into a tenancy from either side of that transaction and then within a matter of weeks decide that it's not for them and vacate. And so there's mutual interest, iHowz say, in retaining fixed terms. But returning to the main proposal, I just want to say a few words about what I perceive the merits to be. And they're really fourfold. First of all, as I've alluded to, it has the benefit of simplicity. Indeed, we've even gone so far as to draft some possible legislation, which you'll find attached to my paper, which enacts the entire regime in a few very short paragraphs. Secondly, it's self-regulating, and I've already alluded to the fact that it incentivises both landlords and tenants to do what's required of them. And because it's self-regulating, it won't clog up an already heavily oversubscribed and overstretched civil justice system. And one hears in debates on this subject talk of, for example, the formation of housing courts to regulate the debates that might arise, and my spirits sink, because there isn't the money to support the systems that exist without thinking about trying to create fanciful and entirely new court systems to deal with these disputes. The third point is that it's beneficial to landlords as it enables them to secure evictions, particularly in the difficult circumstances of antisocial behaviour, which is a topic to which I'll return. And the fourth point is that it's beneficial to tenants. It's beneficial in one very obvious way, which is that on receipt of a notice seeking possession under Section 21, it provides them with a financial cushion which enables them to put down a deposit on alternative accommodation. But it's beneficial too in at least two more subtle ways at the start of the tenancy. First of all, it makes it more likely that landlords will be prepared to grant tenancies in the first place. It's a considerable source of comfort to landlords that they have the cushion of Section 21 in the event that things don't work out, and that enables them to take a gamble on tenants on whom they might not otherwise be prepared to take a gamble. That is in tenants' interests, and iHowz speak of many experiences of extremely successful landlord-tenant relationships which would not otherwise have come into existence. The second way in which no-fault evictions are beneficial to tenants, the second rather more subtle way that is that they act as an incentive to landlords to make sure that the standard of accommodation is safe for tenants to occupy. And that is a result of the additions to the Housing Act 1988, which provided that landlords can only rely on no-fault evictions if they have taken steps as regards, for example, gas safety and energy efficiency, which they are therefore incentivised to do. And abolishing no-fault evictions will, at a stroke, take away that very strong incentive for landlords to behave as they doubtless should. So there are all those benefits to tenants, and I alluded a moment ago, so far as landlords are concerned, to the particular problem of evictions in the context of antisocial behaviour. Now, this is a growing problem, and it's a particularly invidious problem. And the Renters Reform Bill proposes to tackle it by changing the words of the grounds for possession, the existing grounds for possession, from behaviour that is likely to cause antisocial behaviour to behaviour that is capable of causing antisocial behaviour. Well, I can think of very few cases that I've ever been involved in which that very small change would be decisive. And more importantly, it doesn't address the very real practical problems that eviction in these circumstances present. It doesn't address the problem of requiring vulnerable and often frightened neighbours and fellow tenants to come and give evidence. It doesn't address the difficulties of proof. It doesn't address the fact that even if those tenants are able to convince a judge that there is antisocial behaviour, it remains a discretionary ground for giving possession, and even if possession is ordered, orders can be suspended and misbehaving tenants can be given, and frequently are given, second chances. And that's all enormously distressing for the victims of this behaviour, so much so that it deters many people from putting their heads above the parapet in the first place. And nothing that I've actually said probably touches on the most important problem that arises in these situations, which is getting the case off the ground at all, because victims of antisocial behaviour know that they have to put their heads above the parapet for a period of months before the court system will enable the case to be heard. And during that period of time, their lives may become such a living hell that many of them frankly won't do it. And the abolition of no-fault evictions takes all this away. If you have no-fault evictions, a landlord can, at a stroke, and without making anybody put their head above the parapet, remove offenders. So it might be said, well, then people are likely to get evicted in circumstances where they're truly not guilty of antisocial behaviour, and it's better if judges are left to judge that. That is a much less commonly encountered problem than the countervailing problem to which I've alluded a moment ago. It's simply very rare in practice, and I would venture to suggest that most landlords are pretty good at judging when there is a genuine problem that needs to be solved, and when there are other measures stopping short of taking possession that will address it. So that is a really important consequence, I would suggest, of abolishing no-fault evictions. It's one that hasn't been thought through, and frankly the proposed amendment that is contained in the Renters Reform Bill, which I mentioned a moment ago, wholly lacks teeth and will make no practical difference. So it's always a good idea when one is considering alternative proposals to think through the problem cases, and goodness knows there's plenty of property legislation about that has had unintended adverse consequences. But rack my brains though I did in preparing for this presentation, it is actually quite difficult to think of many that would arise. Such is the beauty of the simplicity of what's proposed. One problem that might arise is that obviously what we propose is heavily dependent on the tenant getting the money that they are entitled to. And that might be thwarted in certain ways that it's possible to envisage by the landlord receiving money during the rent-free period and not repaying it. It might happen because, for example, rent has been paid by the tenant in advance before the notice is given to cover the rent-free period. I think that's less of a problem, actually, as I understand that the periods of paying rent are going to reduce to not more than a month. But it's possible, if rent were paid quarterly, that that could happen. Secondly, it might be paid by direct debit or standing order, and that might not get cancelled in time, and it might be paid by inadvertence by the tenant. Thirdly, there are a number of situations where rent is paid by somebody other than the tenant, parents, trusts, and of course, above all, housing benefit. And it might be difficult to stop that money from coming into the landlord. So what is proposed to deal with that situation is that it should be a defence to a claim for possession brought on this ground if the tenant can show that the landlord has received rent during the rent-free period and not accounted for it forthwith to the tenant. So if the landlord receives money and doesn't immediately notice and doesn't pay it over to the tenant to be put to the use that we contemplate it should be put for, they will have no claim for possession. And that again gives a simple thing to enforce, and it incentivises the landlord to be vigilant and to do the right thing in the event that rent is received. What other problems might arise? Well, it could be said that no-fault eviction will just be overused or abused by landlords. Speaking for myself, I don't think that's a realistic objection. Landlords don't want the aggro of taking possession proceedings if they can avoid it. And of course, if they do, under this system, they suffer the financial detriment of losing 2 months' rent. So that's a pretty strong incentive to focus the mind for a landlord as to whether they really should be going down the no-fault route or not. Connected with that, I'm sure the landlords in this room will agree that they simply don't want to evict tenants if the arrangement is working well. Better the devil you know. But sometimes, and the course of legislation reflects this, no-fault eviction is needed. And if you take it away, the pendulum will have swung back to the extreme where it was under the Rent Acts and before the 1988 Act, and in due course it is predictable that this binary and circular debate will cause it to swing back the other way. So that is why this very simple, very imaginative proposal represents a way of breaking that cycle and a really good way of, I would suggest, ensuring, without the need for involving lawyers like myself or judges, that no-fault evictions have their proper place, that they're used in the right circumstances, that they're not abused, and that when they are used, they preserve the power and the dignity of the tenant to be able to go out into the housing market and secure proper alternative accommodation for themselves and their families. And that, in short, ladies and gentlemen, is why I commend this proposal to you. Thank you very much.
Thank you. Any comments or questions from the floor? Sir, at the back.
Hello, MP for Totnes and South Devon. I'm quite interested in this because I think the handling of it is going to be the difficulty, and I'm wondering what engagement you have had with the department already on this proposal. I accept that you may say it's beautiful and well crafted, and I wouldn't doubt that for a second, because I've seen your work in other parts on this matter. But my concern, and I have raised this in the early stages of this debate, and we haven't really got into the weeds on it at all, is that the department is not going to acquiesce on Section 21 because it was a commitment during the manifesto. So we have to look at an alternative measure, so it's a new amendment rather than trying to replace what Section 21 currently stands as. And to be honest, I think there also needs to be a wider conversation about fixed, I'm going to use the wrong terminology, so please forgive me for this, but actually allowing people to have contracts for a certain period of time. The lack of that being available is going to decimate the markets. And I made one other argument, which we were discussing a moment ago. I've got 5,500 second homes in my constituency. of which I would probably argue about 60% of them are Airbnb. I raised it on the floor of the House and have spoken to the Secretary of State about this. My big worry is in financial districts in this country, you will have people coming over here, renting property on the guise of a long-term rent, and then handing it back and giving notice after 2 months. And I'll use the American banker as the example. They'll come over for Wimbledon, they'll come over for Ascot, and they'll hand it back, and there'll be nothing within the law to stop them from doing that. If you've got any thoughts on that, I'd be very grateful.
We're especially worried about the student landlords as well in that situation. So, Vash, is this something you want to pick up? So,
I can say that we have engaged with the department, and their response has been twofold. The first response is it's a manifesto pledge. We argue that a manifesto pledge can be improved and that what we're proposing is an improvement. And their second argument is Section 21 eviction cause homelessness. And as Andrew eloquently put forward, the proposal will reduce homelessness because it's going to provide rent in advance, it's going to provide moving expenses, they should get the deposit back. So on that side, we need to maybe go back to the department and try and get this message over to them. On the point of fixed term tenancies, a lot of tenancy association or groups are saying we want to retain fixed term tenancies because we don't like the prospect of a family moving into a house a month later, the landlord deciding they want to sell or renovate, and they're faced with a 2-month notice. Because I'm a landlord and a letting agent, and I've often entered into 18-month, 2-year agreements with families because they want certainty of contract. So at the very least, there should be something in the bill that either provides for fixed term contracts or contracts that can be ended at any time, so that gives us that flexibility. So I think that answers.
Can you provide some wording for that, by the way?
Andrew's already provided wording at the end of his paper. There's draft amendments.
Not in relation to fixed term.
Not in relation to fixed term, but he will be instructed to do so. And
hopefully you've all got a copy of Andrew's paper. If you've not, then if you've got a copy of this, email us and we can send it through. When you wanted to raise something.
Yeah, Alwyn Oliver from Portsmouth and District Private Landlords Association, a landlord and a letting agent. I just want to talk about antisocial behaviour evictions in particular. Something it seems to me that has not been decided yet, and it is an absolutely key question, is whether if I evict a tenant for antisocial behaviour, assuming I manage to get it through the court, and I'll set that aside, but assuming that life is as intended in the legislation, it's a bit easier for me, will that decision of the court be visible to Peter, his prospective, the tenant's prospective next landlord, through the application process? A county court judgment, money order, would be. The legislation, as I understand it, is currently silent on whether an antisocial behaviour eviction should be published or not. Now, that's a good thing because you haven't made your mind up. I'm going to try and suggest it should be, but then I think if it is, there is a strong case, and here I do slightly disagree with you. I think there's a strong case both for a specialist housing court and a kind of two-way ombudsman, a bit more like ACAS in an employment tribunal, where you try and sort the matter out before it ever gets that far. Because one of the things you mentioned is missing is a restorative pathway, as I would call that, which is to try and pack things up.
So obviously under the iHowz proposal, you actually avoid evictions for antisocial behaviour because you use the no-fault eviction route without that.
Yeah.
Now, as far as I'm aware, under the existing system, if somebody is evicted under ground 14 antisocial behaviour, there is no public record of that. And as you rightly say, there's a county court register of money judgments where I think people's names are entered if a money judgment isn't settled within 14 days or something of that kind. But there's no comparable record other than the sort of public record on a court file of an eviction for antisocial behaviour. And I don't think that's a readily searchable public record.
But I'm suggesting it should be incorporated.
Well, I mean, yeah.
With respect, you've already put an amendment in saying that if mediation or some form of intervention from the landlord is refused, the court can take that into account. You've already said that people who are evicted will be deprioritised for social housing. I agree with that. The government policy is already that you should try and crack down on antisocial behaviour. To give you an absurd example, if my tenant trashes my property, it's a civil matter. If they wake the neighbours up while they're trashing my property, it's a criminal matter. Now, why can't some form of antisocial behaviour be recognised so that we can all know? Because it'll act as a disincentive. It's what you want.
Okay, I'm conscious of
Can I
time.
just say one thing?
Can we just take one in the back there and then come on to you? So,
Just to say that what you should bear in mind is that the iHowz proposal will be a lot quicker and cheaper than pursuing an antisocial behaviour eviction. You'll get far quicker closure and get happier.
but Alwyn's point is about
Yeah.
referencing for the next time round. So, and then I'll come to the front row. So,
Hi, my name is Darshan Sander from Propertymark, policy advisor, political advisor. I'm also a district councillor in Epping Forest, and I work very closely with our esteemed MP, Damon Lang. Now, we've been a councillor myself, and a landlord, and an agent as well. I get the whole picture. So a lot of landlords have been coming to us, a lot myself as well, and their concerns have been around the rental reform bill with the tenancies going, the fixed tenancies going. Now, a lot of the landlords are coming to a period where their rates have been fixed for a certain period, and where
Their mortgage rates.
banks and building societies are now looking for proof to have their security. So how long is your contract? If there's no contract, they're not going to be in favour of giving you a good rate. That's one of my main concerns. And the other thing is surrounding the 98% of landlords never ever want to evict tenants unless their property is being damaged, unless the rent is not being paid. All tenants normally end tenancies quite reasonably. I can share a personal story. I've had a landlord in one of my properties for 16 years and 7 months. Was I getting my rent paid? Yes. Was he looking after the property? Yes. And was I getting the market rent? No. But I was happy to have him stay there. So there are a lot of landlords out there that will work with tenants, and I think we should have the fixed term tenancies because it gives a surety to the lenders.
okay, thank you, Russell. You wanted to say something, so.
Thank you. I find it a very interesting proposal. Lloyd Russell Moyle, MP for Brighton Kemp Town, and I sit on the Bill Committee for this. So I find it is unfortunate that you've come just after the Bill Committee has debated this section. So, but I do think there's some interesting parts that you might be able to bring back at third reading or in the Lords. What I would say is two things. One is there was no such thing as fixed terms for tenants beyond 6 months. Let's be very clear of that. There was fixed term for landlords, there wasn't for tenants. And so there is a problem with the fixed term system because after 6 months a no fault eviction could be pursued even if you had a 12-month tenancy. So there was no guarantee and there was no rent repayment after that. But if the tenant wanted to move out after 6 months, after it's been a year's short tenancy, they would potentially be liable for the rest of the year's rent. So it was totally incoherent. And so I think that clearly it needed to change. And I think that where the debate was up to yesterday is the government and our side on the front bench for Labour and the back benches as well. It was that the fixed there's no way you can restore a fixed term without replicating those problems. Without replicating the problems that actually it's a fixed term for one but not the other, because you are requiring the tenant to have to pay rent for the whole rest of that term if they leave early, but you're allowing the landlord to evict at any time after the 6 month protected period. And so if you could find a way for that to be equal, I think that then we're in game for discussion. Unless you can get that to be equal, I just think there's no discussion to be had, and it's not going to happen.
Okay.
But I wanted to say the other thing is there are no fault clauses on this. There are most of the clauses for eviction are currently no fault that will remain. We're just talking about whether it is no fault and no evidence or no fault and evidence. You know, someone moving in because they want to live in the property themselves is no fault to the tenant. It's a no fault eviction, but you have to provide evidence for it. Mm-hmm. Now, I do think your proposals are very interesting around payment of 2 months rent or the non-payment of 2 months rent for a no fault, of which we have plenty of no fault in here, that currently exist. And I do wonder if there's some discussion about whether that could be extended, because I think you could find agreement cross party on some of that. So there's some elements of this that I do think, but I think the headline of getting rid of Section 21 is gone. So we have to find another form to include your amendments. And secondly, it has to be equal to tenants and landlords, or better for tenants. We can't have a situation where it's better for landlords. I think that's the political consensus at the moment. At the moment, it's not been better for, it's better for landlords and worse for tenants.
I mean, to take a pragmatic view, what I was kind of interested to hear the lawyer's view on this one, that when we have landlords who say, my tenant's left before the end of the fixed term, they are liable for all of the rent. I would say 98, if not 99% of them will say, I won't progress that. You think otherwise, sir?
No, I think you're right, but the bill is designed.
No, okay.
I don't.
Yeah, so let Andrew come on.
I don't. I mean, I'll be corrected if I'm wrong. I don't think that's right. Landlords and tenants at the moment can agree whatever fixed terms they want, and if they've agreed it, it is not open to a landlord to say after 6 months, I'm tearing that up. That's my understanding.
They're entitled to use a Section 21.
I don't think that's.
Not if it's fixed term.
That's right. I don't think that's right.
Short hold tenancy.
It could be for up to 3 years at an AST.
Afternoon, Rodney Towns from iHowz. Sorry for not standing, but I have a disability. All I would say is that we have representatives from both sides of the argument here today, and in a way this proposal delivers to both sides, in that you can say that you've delivered for the tenant side, and we're able to say we've retained what we regard as a usable tool for landlords, whilst conceding financially and in terms of allowing additional time to recognise that we are inconveniencing our tenants' lives. Afternoon, Rodney Towns from iHowz. Sorry for not standing, but I have a disability. All I would say is that we have representatives from both sides of the argument here today, and in a way this proposal delivers to both sides, in that you can say that you've delivered for the tenant side, and we're able to say we've retained what we regard as a usable tool for landlords, whilst conceding financially and in terms of allowing additional time to recognise that we are inconveniencing our tenants' lives.
Okay. Pete, you wanted to say something, sir?
Thank you. One of the things that's been mentioned, and I think is very important, is that this is against the background of a creaking court system. And that's something I deal with every day, and as a solicitor, part of my value to my clients is actually simply knowing good members of court staff, so I can get matters slightly kind of eased through the system. What I would say is a serious problem, is that we're talking here about notice periods and 2 months, but if you do go to court, whilst the legislation requires you get sort of a hearing in 8 weeks, that's a 5-minute hearing, which will be adjourned at the slightest width of an issue, and quite you know, judges don't. And I think members of Parliament who aren't familiar with the civil justice system, who will be considering this, will be shocked at the state that the civil justice system is in. So a 5-minute hearing that is adjourned on a landlord and tenant claim in many courts in London that I deal with quite possibly won't come back to court for over 6 months. So you cannot blame landlords for wanting to use the route which they think, no matter what the basis of wanting the eviction, whether it's antisocial behaviour, rent arrears, whatever, often they will use the Section 21 notice because the court system is so tied up that they want the simplest system where the least can go wrong, and they will often use that system to their cost because the only generally fixed costs are available. So I would ask that any members of Parliament sort of considering the proposal and also the current system look at the state of the court system and think practically about how the legislation will work with that, because my experience of working with landlords is that if they have especially if they're sort of landlords on a relatively small scale, if they have a possession claim where a tenant decides to sort of fight it and puts a lot of energy into that, rightly or wrongly, it takes so long to unravel, and they end up with you know, it ends up going on for so long, and it's so financially crippling that landlord will not want to rent the property again and will want out of the market, as it can just be financially ruinous where they have a mortgage to pay for a year and no income coming in. So I think that's a real danger to landlords if we lose the Section 21 notice without some sort of proper redress.
Cool. Thank you. Sir?
There's more a plea actually.
Okay, we like pleas.
Zoom in a couple of weeks, because I have a full intent to try and put amendments down report stage when it comes
We
back.
will be in touch with you, don't worry.
My whips didn't put me on the bill committee for the obvious reason that I would have tried to take things out, and so I'm sure that may reassure some people in this room, but it would be very, very helpful from my point of view, from what we've discussed today, to have some other suggested amendments that go along that we can also run across the bill committee, because, not the bill committee, the clerks here, because I would say from the Conservative benches, there are 20 or 30 I could probably name off the top of my head who aren't with us tonight, who do want to be able to make sure we get this into the right place and find that balance between landlords and tenants. And credit to the shadow leader of the Labour Party, deputy leader of the Labour Party, who stood up and spoke about the social value of landlords. You know, that's what we've got to get right. I think there's cross-party unity in some of these areas, and we can make it work.
I mean, we said earlier on, we had a conversation earlier on, and although we're a landlord association, we represent the PRS as a whole, and tenants are very much our customers, and we do sometimes help tenants out on our helpline. It's not unknown, because we don't want bad tenants, we don't want bad landlords. Unfortunately, you may think differently, but they are in the minority. You know, we really don't want them. So what I would say, I'm going to come on to you, I can do. You've got this, which has got various things in it. One of the things is our view of the bill as a whole, where we're not saying just throw the whole thing out. There are bits which we can take through and discuss a bit further. It also goes into some other points that we want to bring forward.
Can I just make some suggestions to try and bring this together? Because we've now heard that the bill has been discussed in committee at this particular part of it. So any amendments or new clauses will have to be put down at report stage. We've heard that there is a cross-party consensus that Section 21 must be abolished. Therefore, if a new clause or amendment is going to make any progress in the Commons, it needs to be drafted in a way that is not an amendment to Section 21, but is essentially a new proposition, maybe centred around a fixed-term tenancy with the ability to be able to end that tenancy on a particular basis, or having as a condition of that tenancy that there would be compensation if it was brought to an end earlier. But in order to be able to make any progress, I think you're going to have to ask your Andrew here to draft a new clause or two, or for debate at report stage, which doesn't build on Section 21, but accepts that the consensus is that Section 21.
Roughly how long after the final hearing will that be?
Well, basically, we've got a situation where the bill went through on second reading. There's a timetable motion, which means that the committee proceedings, as I recall it, have to be finished by the first week of December. After that, there could be report stage at any time in the Commons. That may well not be until the new year, but you couldn't bank on that. And the sooner you put down new clauses, the more likelihood of them being able to be debated. Your propositions, which you put together on this, which are really constructive and thoughtful, in my view, may be able to get more mileage in their Lordship's house, which is because of the way in which the Commons now operates, is the reforming chamber. It's the chamber that actually looks at new propositions. And when Anthony Magnell says that because he had concerns about this bill, he was not invited to go on the committee, can I tell you that when I was taking the community charge legislation through this House, we made a point of actually having some of the strongest opponents from the government side against that legislation actually on the bill committee, particularly Lord Young, who is of Cookham, who is still there in their Lordship's house. He was on the backbenches arguing the cause of dissent, but we've now moved away from that, so the only people who will get on a bill committee from the government side are nodding donkeys, and I'm afraid that is a serious indictment of our legislative process. But that's another story. But well, unfortunately, we haven't got this room for much longer. But
we're another 10 minutes.
Can I say? I'm going to invite some other people, or you can invite some other people to join in this discussion. But we need to come to some sort of conclusion as to where we can go to from here, because it's obviously a really good idea behind all this, and we've got to be able to put it forward in a way that it would be the subject of legislation. And
we have a proponent over there, I believe. So yeah. All right. Okay. Thank you so much for sponsoring us. Much appreciated, especially you had to dive in a late minute. Andrew, thank you so much for the work you've done and putting it forward in a very succinct way. And thank you all for coming. There is still some wine, etc. over there. Can
we ask Andrew, through you, whether he thinks his proposition could be incorporated in new clauses in the way that I've described it?
I'm sure it could be. Time is always the enemy, but I mean, we'll see what we can do. And I'm obviously not a statutory draft person, so I can do my best. But it's often the problem with this consequential amendments of the difficulty. You suddenly find there's some section somewhere that needs to be repealed that you don't know about.
Yes.
I mean,
I can imagine. So.
I don't think it would take much of an adaptation of what's been drafted so far to build it into the existing bill.
All right. Okay.
Confessing to the fact that I'm Andrew's father, but also a member of the House of Lords, I mean, what Sir Christopher said is quite right. I think if you're going to have any prospect of this, the thing to do is to persuade, is to talk to the Labour Party, because it'll be the Commons. The Lords will do what the Commons Labour Party say, but if you can sell them a proposition which is consistent with their policy, they've got a very good chance of getting it through the Lords. Okay. If there's then some sympathy from it on both sides in the House of Commons, then that I think is the only route by which you will do it. And I absolutely agree. It's no good trying to get rid of the abolition of Section 21. That is in both parties' manifestos. You've got to approach it in a different way.
Okay. Thank you very much.
Yes, thank you. Yeah. Any more for any more? Thank you so much all for coming. If you've not read